Good morning to all of you. Honorable Justice Sri Krishna, Mr. Manoj Mitta, friends. The subject of my talk is Judiciary versus the Legislature. If I spoke in Parliament, most likely no one will be allowed to speak. If I spoke what I wish to say in court, it's likely that I'll be hauled up for contempt. So the only place I can speak is before you. Clearly, there is jostling for space between the legislature and the judiciary. That's an undeniable fact. Parliament and the legislature will say that we are exercising powers conferred upon us by the Constitution, and we are not encroaching upon the judiciary's powers. The courts will say we are exercising powers conferred upon us by the Constitution, and we are not encroaching upon the legislature's powers. Clearly, both of them are being economical with truth. The fact is, and every student of law, every student of politics knows that there is a jostling for space between the legislature or parliament and the judiciary. We can approach this subject by looking at what gave rise to this tussle. I think there are two trends, and that is what I wish to speak about. The first is the decline of legislative power. It's hardly necessary for me to elaborate on each one of the points that I wish to make, because all of you will clearly understand and comprehend what I wish to say without elaboration. The decline of legislative power. I believe it is for three reasons. Firstly, Parliament and legislatures devote or spend fewer hours inside the House engaging in debate. There are state legislatures which meet for no more than 5 or 6 days a year. At best, they could meet for 15 days a year. Parliament, of course, meets in the 3 mandatory sessions. But that is about all. It meets. It does no more than meet. Therefore, if you count the number of hours which Parliament and legislature spends in the discharge of their duties, you will find there are fewer and fewer hours as every year rolls by. The second reason is there is poorer debate. There is 0 hour, which consumes a lot of time. There is question hour, where questions hardly elicit full and frank answers. And then there's a lot of acrimony, but there's very little debate. In fact, since I've been elected to the Rajya Sabha in July last, we've had only one debate in the Rajya Sabha, and that is on the GST. And that is the only occasion where I spoke. I'm paid a huge amount of money to be a member of Parliament, but I've spoken exactly for 30 minutes since July 2016. There are others who wish to speak and who have not spoken. There are others who do not wish to speak and are happy that they have not been allowed to speak. But the poorer debate, when debate takes place, is rather disappointing. The third reason for the decline of legislative power is weaker political authority. Yes, in some states there is very strong political authority because governments have a huge majority in the legislature. But as far as Parliament is concerned, in 30 years, only the last election threw up a government with an absolute majority in the Lok Sabha. We've had a succession of minority governments, and the weaker or the weakened political authority is apparent to anyone who sits in Parliament. In fact, the problem is compounded because the Rajya Sabha is often contrarian to the Lok Sabha. The cycle of election to the Rajya Sabha and the cycle of election to the Lok Sabha are different. And while the people may have voted a party with an absolute majority in the Lok Sabha, it will take at least 3 biennial elections for the composition of the Lok Sabha to be reflected in the Rajya Sabha. And by that time, there would be another Lok Sabha election which may change the composition of the Lok Sabha. Therefore, the Rajya Sabha is often inevitably contrarian to the Lok Sabha, and that again weakens political authority. And I'm not suggesting answers. I'm only laying down the 3 main reasons why I believe there is a decline of legislative power. Now we look at the other side of the coin, the rise of judicial power. How has the judiciary become so powerful? It's the same constitution. It's the same courts. And the judges are drawn from the same closed shop of lawyers. In fact, that is the only institution which is a perfect closed shop. You can only have a judge who's either a lawyer or a lawyer who's become a subordinate judiciary judge. Yet, the rise of judicial power is undoubted. And again, there are 3 reasons. The first reason is they've exercised their power of interpretation very cleverly and very astutely. Simply by interpreting existing provisions differently, they've given themselves enormous judicial power. They have interpreted Article 136 creatively. They've interpreted Article 142 creatively. They've interpreted Article 141 creatively. And that has given enormous power to the judiciary. The second reason for the rise of judicial power is the expansion of jurisdiction. The Supreme Court is a constitutional court, was conceived as a constitutional court. Today it's virtually an appellate court. In fact, sometimes it's an appellate correctional court, which is why the Chief Justice of India has referred the question to a 5-judge bench where the courts of appeal should be created between the High Court and the Supreme Court. The numerous poor quality judgments that come from the High Court deserve correction. Question is, should they be corrected by the Supreme Court, or should there be a proper appellate court to correct those errors, and the Supreme Court become a purely constitutional court? By exercise of appellate jurisdiction, the Supreme Court has vastly expanded its powers. There are many examples. For example, while hearing objections to arbitration awards, the Supreme Court or the High Court virtually, and in many cases, acts as an appellate court. We can multiply examples, but I won't take your time on that. The third reason of the rise for judicial power is judicial activism. From time to time, we have judges who are activists who are active. Now, there's nothing wrong with that. It's not meant to be a criticism of judges, but there are judges who are activists, who are interventionist. And when we have judges of that kind in the High Court and more in the Supreme Court, inevitable result is the rise of judicial power. We have had examples of courts levying a cess. Now, that's a power exclusively for Parliament. No court has the power to levy a cess. No court has power to review budgets, but there are orders where courts have started reviewing budgets for specific purposes. There are many, too numerous to be recounted here, many examples where the executive functions have been virtually, practically taken over by the courts. There's one High Court which has established a committee naturally presided over by a retired High Court judge to prepare a plan how heritage buildings should be preserved. Now, that's a pure function of the executive. And to submit periodic reports to the High Court. It should be an executive-appointed committee submitting periodic reports to the executive, which should be answerable to the legislature. But both wings have been bypassed, and here we have a committee reporting to the court how heritage buildings should be preserved. There was another case, I can't readily recall which one, where a committee was appointed to examine manholes in a city and why manholes were missing and why manholes were not being fixed properly. That's a purely executive function. I mean, each one of us knows numerous examples where judicial activism has enhanced the power of the judiciary. So on the one hand, you have the decline of legislative power, you have the rise of judicial power, and the result is obvious. The result is a complete imbalance in the very fine balance struck by the Constitution. The famous statement is, when two elephants fight, it's the grass that suffers. When the judiciary and the legislature are in a tussle, the executive virtually is vanquished. The weakest of the three institutions today is the executive. And that's the only institution you elect. The only institution you and I elect is the weakest of the three institutions. The legislature is also elected, but part of it is indirectly elected and part of it is directly elected. Now this tussle has reached its highest point in the National Judicial Appointments Commission. I think it's very unfortunate that this has not been resolved. I've written about it, so I don't wish to speak at great length, but clearly, in my view, the article in the Constitution today stands on its head. The Constitution says the President shall, in consultation with the Chief Justice of India and such judges of the Supreme Court and the High Court that he may deem fit, appoint judges. I mean, that's sum and substance of the Constitution. The President shall, in consultation with the Chief Justice of India and such other judges of the Supreme Court and the High Court, appoint the judges. Today, we all know what it means is the Chief Justice of India shall, in a collegium, in consultation with the executive, appoint the judges. It is an article that stands on its head. And obviously a way has to be found out. And I thought the NJAC was a way to resolve the issue. Of course, you can point to examples from both sides. You can point to examples where The Prime Minister has the sole authority to appoint judges. The President has the sole authority to appoint judges. Such examples are Australia, Canada. You can also point to examples where the President has the authority to appoint, but on the advice and consent of a wing of the legislature. The best example is the US. You can also point to example of the UK, where a broad-based Judicial Appointments Commission, including laymen, please remember, including laymen, select the judges. So there's no one model to follow. We have to evolve our own sui generis model. And the model we have evolved, it can be give and take, but ultimately it must be a model which gives a role to the judges, a role to the executive, and a role to concerned people outside the judiciary and the executive. And therefore, a broad-based judicial commission seems to me, in my respectful submission, the answer. It's a pity that the government and the judiciary cannot agree upon who should be part of a 6 or 7 or 8 member judicial commission. I was dismayed when the Supreme Court said, who are these 2 eminent jurists? In fact, it first said eminent persons, then it was amended to say eminent jurists. Are we seriously suggesting that if constitutional functionaries put their head together, they cannot agree upon 2 eminent jurists in this country? Or are we suggesting there are no eminent jurists in this country? I think it's a pity that this deadlock has continued for nearly 2.5 years. It's a pity that vacancies are mounting. There are 7 vacancies in the Supreme Court, and there are over 430 in the high courts. Even if all the judges' vacancies were filled, it will take us 50 years to liquidate the arrears of cases. So I think we are at a point where the subject deserves serious attention. The decline of legislative power, the rise of judicial power, the jostling for space between the 2 executives, the vanquishing of the executive, and the deadlock that we face in appointing judges. So there's a lot of food for thought. My job is only to raise the questions, not furnish answers. And I'm sure, and I'm very happy to see so many young scholars here, young people here. This is your country. You will inherit it. Every generation will inherit it. It's for you to decide what kind of a democracy, what kind of a republic, what kind of institutions we will have. Each of these 3 institutions are critical to a functioning republican democracy or a functioning democratic republic. So I urge you to pay serious attention to the